an advisory jurisdiction, which can only be triggered by a member state, but not by an individual. The court, national courts can, in fact, they are obligated to refer any question relating to the interpretation and application of the treaty to the court. Now, the difficulty about that provision about referring, national courts referring matters concerning the interpretation of the treaty to the Caribbean Court of Justice is that if that problem arose in a national court, there probably would be an objection that the CCJ has exclusive jurisdiction over the application and interpretation of the revised treaty, and therefore the national court is unlikely to entertain any issue concerning the revised treaty. And secondly, the other difficulty about Article 214, that any issue concerning the revised treaty must be a matter between a member state or a member state and the community. So a national judge cannot entertain a matter between a member state and an individual, because the only way you can have such confrontation or an encounter is if you come directly to the court and the court gives leave under Article 222, because as you know, individuals normally do not have locus standi in international law. So that the attempt to introduce referrals from national courts seems to me to be in need of some reform. As regards the independence of the court, the heads of government have taken great pains to insulate the court from political influence. A vital element in the strengthening of the regional integration is demonstrating that the independence and impartiality of the court. Judges are appointed by a regional judicial and legal services commission, and there is a clause which says that members of the commission shall neither seek nor receive instructions from any body or person external to the commission. So that independence is guaranteed in that way. Similarly, the president of the court, when he is appointed by the heads of government, in fact, he is appointed by the heads of government, but the heads of government can only appoint someone who is recommended by the regional judicial and legal services commission. But at the end of the day, salaries and allowances of judges can only be paid with the approval of the heads of government. And the withholding of approval by the simple device of deferring a decision on such emoluments is a potentially dangerous inroad on the independence and impartiality of the judges. In fact, we recall that Article 28 of the revised treaty generally requires unanimity, and it means that a single negative vote can veto a decision. So that those of you who are in the Eastern Caribbean can remember that in one case, a judge could not become Chief Justice because there was not agreement by a particular Prime Minister. So that a single negative vote can interfere with the terms and conditions of the judges of the CCJ. And I think that is a great misfortune, a great defect of the present structure. Financing has been carefully looked at in terms of the Caribbean Court of Justice Trust Fund. The capital of the fund was some 100 million US, which was raised on the international market by the CDB and lent on to the respective governments. And that sum, I think, has largely been repaid by the respective governments. Technology, again, in that respect, the court itself has been fortunate to equip the courts of most of the territories with video conferencing facilities. And this equipment provides better communication between the courts of the region and including our court, so that we are able to hear matters by audio conferencing or video conferencing without necessity for clients or litigants to come to Port of Spain for every single interlocutory matter. And that, I think, introduces tremendous savings and gives greater access to the population, to the CARICOM citizens, to the court. So that, I think, is an advance in terms of the Caribbean Court of Justice. But the impact of the court and its role in the CSME can only be discerned by looking at the jurisprudence. And here we come to the question of individuals having access to the court. As you know, some of you know, in international law, the subjects of international law are, strictly speaking, member states. There are exceptions to that. But what has happened in the revised treaty is that in Article 222, it is provided that an individual may approach the court and ask the leave of the court to bring a matter against a member state. And that is, in fact, providing and guaranteeing the rights of CARICOM citizens to realize the rights which they have. For example, the rights of free movement and so on. And that is what happened in the Myrie case, that in fact, Ms. Myrie came to the court and asked for special leave to bring a case against the Barbados, because she had to satisfy certain requirements. For example, that her home state, Jamaica, did not wish to espouse her case, or in fact agreed that she should bring the case instead of Jamaica. And there are other requirements of that kind. For example, that you have to show that you are personally prejudiced by the action of the defendant state, and so on. But we have very liberally interpreted the question of locus, so that a corporation, say a Guyanese corporation, which was dominated in its shareholding by Trinidad shareholders, could still be regarded as a Guyana company with rights to bring action at the CCJ as a Guyanese citizen. So that in one of the cases, we have a Guyanese subsidiary of Trinidad Cement Limited bringing a case against Guyana. And the fact is that most cases that have been brought so far in the original trade jurisdiction have been brought by individuals. And that is not surprising, because there is a general reluctance of states to sue states. And in fact, in the European Union, you'll find that most of the important cases were brought by private citizens. The famous case of Van Hentin-Loos and the case of not release of beverages, Van Hentin-Loos and the Costa and Enel. Those cases, which are fundamental to European Union law, having to do with the supremacy of the community law and having to do with the right of the primacy of a European law and the direct effect of European law into the national law. Those two major pillars of the jurisprudence of the European Court were established by individual action. So that we also have given greater access to the private citizens, private corporations of CARICOM to come to us and to bring their complaints. One blot on that is that you can only sue a member state, and that is what happened in the CARICAD case, Johnson and CARICAD. CARICAD is the community, the Caribbean Community Administrative, the Caribbean, get the exact nomenclature, but it's an associate institution. And that case said that since that association, the Caribbean CARICAD, was not a fully an organ or body of the community, that body could not be sued in our jurisdiction. So that if CARICAD had been a member, it could be sued, but since it was merely an institution of the community, it could not be sued at the CCJ. Now, steps have been taken or are being taken to remedy that, and I am told that there is now, in the process of negotiation, a Caribbean Community Administrative Tribunal, which will enable such complaints to be dealt with by Caribbean Administrative Tribunal. Now, as to remedies, even though the treaty prescribes no remedies for the breach of its provisions, the intention must have been to give the court a free hand in deciding what remedies, devising remedies for breach of the provisions. And we have done so. And we have held that the CARICOM institutions of CARICOM are subject to judicial review. And we held that in the TCL and CARICOM case. But we did say that the court had to strike a balance. It had to be careful not to frustrate or hinder the ability of the community organs to enjoy flexibility in the management of the community. On the other hand, the community had to be accountable, respect the rights accorded to private entities under the treaty, and should not disappoint legitimate expectations. So in laying down these markers, the court was delineating its own legal system. The subjects of that legal system are not only the member states, but their nationals. Rights are granted expressly or indirectly because of obligations imposed by the treaty on individuals, member states, and the community. So that what the court has done by its jurisprudence was nicely summarized in the case of TCL and CARICOM, where the court said, by signing and ratifying the revised treaty and thereby conferring on the court ipso facto a compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of the revised treaty, the member states transformed the erstwhile voluntary arrangements in CARICOM into a rule-based system, creating and accepting a regional system under the rule of law. That really is the major contribution which the jurisprudence of the CCJ has made to the CARICOM, so that we are no longer operating on a voluntary system. The CARICOM and the Caribbean Common Market, that operates in context of the rule of law, and that is important to bear in mind. Now, in terms of, having said that, there is a deficit in terms of enforcement. In the treaty itself, there is no provision for the enforcement of judgments of the court. And in the Guyana case, TCL and Guyana, Guyana had failed to comply with the court's orders for some 4 months. Now, eventually they did comply, so there was no problem there. But there's another case, the Rhodesia Beverages and Guyana case, in which the court has had to lay down a timetable for compliance. And in that case, damages were awarded against Guyana. Well, not damages, but compensation was awarded against Guyana. And that, to date, has not been paid. But there are compliance provisions that the court will seek to impose on Guyana. Nonetheless, at the end of the day, the fact of the matter is that in our CARICOM countries, there is no case where the state can be compelled to pay damages ordered against it because of the provisions of the Crown Proceedings, State or Crown Proceedings Act. So that, what then are the further contributions of the court? And that is based mainly on its interpretation of the act, now, of the treaty. You'll recall that the treaty says that we are governed by international law. And international law lays down if you go back to the Statute of the International Court of Justice, it says, among other things, that the general principles of law recognized by civilized nations will be the basis of international law. And the Caribbean Court of Justice has applied general principles of law, just as the European Union has applied general principles of law established in recognized courts, that in order to facilitate its adjudication of matters. And in the Mairi and Barbados case, the requirement of giving reasons to a traveler denied entry was based on one of those general principles, the principle of accountability, which forms part of community law. So that the court is in the process of building what is community law, and one of the methods or mechanisms it uses is recourse to general principles of law, some of which are derived from international law, and some of which are derived from the law of the common understandings of the law in the member states. And in the case of TCL and Caribbean Community, what we said was that this court may take into account the principle and concepts common to the laws of member states. The search is for general principles of law common to member states. It is sufficient if the general principle is widely accepted. And these are the tests we said that will have to be applied if this court is to be asked to strike down the decisions authorizing suspension of the CET on grounds that derive from domestic law applicable to judicial review in common law jurisdictions. And in this area, we have, in the area of remedies, two judge-made principles are apparent: the principle of effectiveness and the right to protection of community rights. And you will see that illustrated in the TCL and Guyana case. So, what is the outlook? Although the CCJ is anxious to carry out its mandate, questions have been raised in academic circles and about the propriety of a court approaching cases before it with a preconceived mission or agenda that it must provide an answer that promotes regional integration. Does that affect the impartiality and independence of the CCJ? A good antecedent for having just such an agenda is the European Court of Justice. And I think the case of Van Hentenloos and Costa and Enel are classic examples where the principle of direct effect and the principle of the supremacy of community law was established in the European Union. Secondly, I'm concerned that the concept of the CSME, of which the CCJ is an essential part, has been virtually mothballed. I dare say that the strategic plan suggests that that may not totally be correct. Now, CARICOM has a net food import bill of 4.75 billion US. The Jamaica number is 1 billion US. The Trinidad number is 950 million US. Yet I have not seen any plan to pool the resources of Guyana, Suriname, and Belize with their large expanse of arable land and freshwater resources, and to enable CARICOM to be at least self-sufficient in food. Now, one cannot say that because no cases have come to the court on food security for the Caribbean, that there is no plan, and I'm not saying that. But the trend of the cases coming before us is the trend is increasingly towards international human rights law and away from the grand economic design of the CSME. The third observation I'd like to make is that Article 214, dealing with referral from national courts, does need some revision, and the same for Article 222. There is still no supranational commission like the one in the European Union to bring cases to the court or to police and enforce the revised treaty. In any event, many constitutions of the Caribbean say that their constitution is supreme. Does that mean supreme over community law? Again, decisions of competent organs of the community are still subject to the relevant constitutional, I quote here, the relevant constitutional procedures of member states before creating legally binding rights and obligations for nationals of such states. And that's Article 240. In Myri and Barbados, the court wrestled with this very difficult article, and I hope successfully. My fifth observation is that of even more concern is the protocol of the revised treaty of 2005, which seems to be very little known, and that protocol requires the insertion of the following article. The provisions regarding the original jurisdiction set out in this chapter shall not be construed to require a contracting party to enact legislation that is inconsistent with its constitutional structure or the nature of its legal system. So basically that seems to be saying, pay lip service to the community law and do whatever you were doing before. But I don't know that that's necessarily a correct interpretation, but I do say it does put tremendous difficulties in the way of the general application of community law throughout the territories. Yet there is hope, and Kirkham reminds us that for many writers, it was not the Commission, that is the European Commission, that was the real driving force behind the European Economic Community in its formation, in its formative years, but the Court of Justice of the European Community. So he's saying that it was the European Court that really was the driving force. And it is hoped that the Caribbean Court of Justice would achieve similar success in building and strengthening the Caribbean economic integration. Thank you very much.
I thank the Honorable Justice Ralston Nelson, Senior Judge at the CCJ, That has been truly enlightening, truly enlightening. I wish now to invite the Honorable Steadroy Cutie Benjamin.
Thank you very much, Mr. Chairman. All protocols observed. I'm satisfied that it is discussions such as these that can properly explain the role of the Caribbean Court of Justice within the context of the revised CARICOM Treaty. Before I continue, however, I think it's important because most of my statements this morning will be dealing with the role of Antigua in this movement, which have resulted not only in the CARICOM Treaty, but in the whole concept of regional integration. One can recall way back in the 1950s, when we started the Federation movement, Western Federation, people like Byrd, Bradshaw, Burnham, the Jamaicans, the Barbados representative, who were concerned that we must develop in the West Indies a federation, not only as parliament, but a federal court as well. Regrettably, in 1962 thereabouts, that came to an end. The famous historians have indicated 1 from 8 leaves nothing. That wasn't it anyway. We continued, and the development was that the true West Indian politicians wanted to ensure that we had a region that was integrated, a region where persons can travel freely, a region where people could work, transfer of goods and services, and at the same time a system, a judicial system, which will promote Caribbean jurisprudence. That is the object of this entire situation. We went on after the Federation broke up. It was at Dickinson Bay here in Antigua that Byrd, Barrow, and Burnham started CARIFTA. We can remember CARIFTA, the forerunner of what we had today. After CARIFTA, we went on to what we have today, the CARICOM. And the concepts remain the same. Because you see, to be a true federal government, to be a true integration region, we must have the organs, all the organs must work together for the common good of the entire region. There are many persons, regrettably, who are of the view that the Caribbean Court of Justice, as the final appellate court in the region, is not yet ready. I do not share that view at all. The Caribbean Court of Justice is staffed by and selected, the judges are, of very great academic competence. The chairman, the president of the court, Sir Dennis Byron, the brother of my friend right here, Fruity Byron from St. Kitts, is an outstanding legal luminary. And the complaints have always been, do we, they say, in the Caribbean, have the type of judges who will be able to render decisions which people could say are binding, well-founded in law? I've discovered also that many senior practitioners who might have been trained in England are biased towards the English system. They're saying, look, the law lords who have specialized in their fields for years have the competencies in their specialized areas. They are saying, they argue, that the persons who sit, they say, on the court at the moment may not be experienced as those in England. I beg to disagree. And I'm asking the people around this region to disabuse their mind from that type of suggestion. I'm inclined to the view, the very firm view, that in order that we can be an independent nation, a region as a whole, this is a natural progression from slavery to colonialism to independence, to regional integration. That's the whole concept of what the West Indian man is all about. And we cannot be really true, an independent nation, except we have in the region a court, the CCJ, which is the final court to determine issues involving not only states, but persons within the states as well. It's a sad day that only 4 countries so far have signed on to the appellate jurisdiction. It is obvious that the court has done very well with respect to the original jurisdiction. The Mairi case is but an example. That Mairi's decision is accepted throughout the length and breadth of the Caribbean, and it governs how immigration departments will treat with persons as they traverse the Caribbean from island to island. And I dare say, you may pose this question to me. Yes, that may be in its original jurisdiction, but what about its appellate jurisdiction? A famous case was decided by the court dealing with criminal matters. It says that where somebody has been incarcerated and that individual is to be sentenced, then the time spent on remand must be taken into consideration when computing the sentence of the person who was convicted. I'm very pleased to say that in Antigua and Barbuda, quite recently, we amended our Criminal Law Act to make it applicable to this jurisdiction as a matter of law, meaning any person tried, convicted, and sentenced, and during the time he or she awaits sentencing, a particular period of time has elapsed. When computing the time within which that person must remain in prison, the time spent must be deducted from the sentence the individual is to serve. The Caribbean Court of Justice has a very important role to play within the context of the revised CARICOM Treaty. It's important in that it has to interpret